Subcommittee will now come to order, and I'm pleased to welcome you today to the hearing before the Subcommittee on Crime, Terrorism, and Homeland Security on indigent representation, a growing national crisis. Our criminal justice system has been referred to as a three-legged stool supported by the judges, prosecutors, and defense. If you remove one of those three legs, the stool collapses, and we're here today to talk about the third leg of the stool, the defense, and whether or not that leg has in fact collapsed. Researchers have estimated that between 80 and 90% of all state criminal defendants rely on indigent defense systems for counsel. This number will likely only go higher with our increasing rate of unemployment and the economic downturn. In March, we held a hearing on problems of indigent defense systems in the state of Michigan. This hearing focuses on the status of such systems nationally. Two significant reports have been released since our last hearing. The first report of the National Right to Counsel Committee, titled Justice Denied, America's Continuing Neglect of Our Constitutional Right to Counsel. The other report was prepared by the National Association of Criminal Defense Lawyers and is entitled Minor Crimes, Massive Waste, the Terrible Toll of America's Broken Misdemeanor Courts. Both of these reports are the result of multi-year studies. Both reports also confirm what we suspected at the last hearing, that the indigent defense systems are suffering all across the country. In 1991, the Department of Justice report concluded that indigent defense was in a chronic state of crisis. A 2004 study by the American Bar Association similarly found that caseloads for public defenders far exceeded national standards in many cases, quote, making it impossible for even the most industrious attorneys to deliver effective representation in all cases. A recent New York Times article reported that public defenders' offices in at least 7 states either had refused to take new cases or had filed lawsuits to limit caseloads. With only a few exceptions, the situations are only getting worse and the consequences are devastating. One of our witnesses today, Alan Crotzer, was convicted of a crime he never committed, spent 24 and a half years in prison before being exonerated by DNA. The first time he met his court-appointed attorney was 3 months after his arraignment. He told his lawyer he had an alibi, and there were witnesses who could testify on his behalf. His lawyer never even bothered to interview those witnesses. The NACDL's report, Minor Crimes, Massive Waste, found that many defense attorneys were carrying excessive caseloads in misdemeanor cases. Their caseloads far exceeded the only existing standard of 400 misdemeanor cases per year, and many believe that that standard, developed over 35 years ago, is too high. In Illinois, Florida, Utah, for example, many jurisdictions report average misdemeanor caseloads exceeding 2,000 per year. An attorney carrying a caseload of 2,000 cases could spend about 1 hour and 10 minutes on each case, total. That attorney would have to meet his client, read the police report, conduct relevant discovery and research, prepare for court, write motions and sentencing memorandum, and appear in court, all within that 1 hour. New Orleans has an average caseload of almost 19,000 misdemeanor cases per year, which leaves about 7 minutes per case. The report of the National Right to Counsel Committee revealed similar problems in felony cases. In Miami, average public defender caseloads have increased in the past 3 years from 367 to nearly 500 felonies, while the public defender's office's budget has been cut by over 12%. These numbers compare to a maximum national standard of 150 felony cases per year. Everyone agrees that indigent defense as a whole needs more funding, but no one wants to pay. We continue to fund local and state governments with increasing law enforcement and prosecution resources, but we refuse to give money to defense. In the meanwhile, innocent people like Alan Crotzer continue to be convicted and real perpetrators walk free. The existing disparity and imbalance in the system continues to grow and hits minorities especially hard given their overrepresentation in the criminal justice system. This problem is exacerbated by the trend in the last several decades for more mandatory minimum sentences and overcriminalization of conduct. I've been working in the field of criminal justice for a long time, and I thought I'd heard everything, but yesterday I learned that it is a crime in Nevada to feed the homeless in a city park. In New York, apparently sleeping in a cardboard box or even sleeping on a subway is a crime. When we don't like certain conduct, all too often our response is to make it a crime. In many such instances, a more effective and less costly response might be to consider education, prevention, or treatment. All of this leads to the question of whether indigent defendants are being deprived of their Sixth Amendment right to counsel in the United States Constitution. Most everyone seems to agree that the resounding answer is yes. So what can and should Congress do to address this issue? The National Right to Counsel Committee has two recommendations that we should consider seriously. First, the committee recommends that the federal government establish and adequately fund an independent center for defense services. The function of the center would be to assist and strengthen the ability of the states to provide quality representation to both adult and juvenile criminal defendants who cannot afford to pay for legal services. Almost 35 years ago, the federal government created a similar national program called the Legal Services Corporation to help states provide legal services in civil cases to people who could not afford to hire attorneys. The need for a similar national entity to assist states in meeting their requirements under the Sixth Amendment is even more compelling. Second, they call for a federal research and grant parity. Congress currently spends billions of dollars on programs to states and local governments to enhance local law enforcement and increase prosecution of crimes. We have an adversarial legal system. For justice to prevail under such a system, the playing field needs to be level, and both sides need to be adequately funded. Congress cannot continue to fund only one side of the system if we're to be assured of an effective and just system of justice in order to conform with the Constitution. I look forward to hearing from our witnesses about how we can address these problems, and it's now my pleasure to recognize the ranking member of the subcommittee, the gentleman from Texas, Judge Comert.
Thank you, Mr. Chairman, and I do appreciate the interest in this issue. Appreciate the witnesses being here. And of course, anytime the justice system fails one person, it is a very serious failure for the whole system. And I know that everyone has their testimony prepared, and the statements are going to be very helpful. We've got some good insights into future solutions. We don't have anybody who's come in today. I could have brought dozens if I'd known in time, and that's no fault of the majorities. People who can come in and point to some excellent indigent defense that is going on across this country. So it concerns me, knowing so many indigent defense attorneys across the country who often get a bad rap, who are dedicated to doing a good job, usually don't get paid adequately, but take their jobs so seriously that they do all they can. And I know there are attorneys like that, because even though I did civil litigation, I was appointed to appeal a capital murder case. I think it was nearly 800 hours I spent on that case. And I did a good job, not because I was going to be properly compensated, because I knew I wouldn't, but because it was an oath I took to properly represent my client. My client got good representation, and his case was properly reversed after we took it to Texas highest court. There's good representation going out there, far better than I provided. There is good representation in many areas in the country, and hopefully somebody will be willing to acknowledge that as well, even though there are problems. Then there's differences on how you address a problem. What we hear in Washington as we become more and more bankrupt as a nation because we cannot control our spending, and I was hoping that when even though the Bush administration, the prior majority, had spent too much money, that when we were promised change, we were going to get change and not keep spending ourselves into bankruptcy. But there's been no change other than accelerating the course we were already on to bankrupt this country even faster. So when we look at where should the federal government be spending its money, then we should look carefully at what are the constitutional requirements. Constitutional requirements are clear, and as some of you have discussed, Gideon points that out. There is to be proper representation of everyone in a court, state, federal, or otherwise. And one of the witnesses will properly point out and make the good point that even though it's also required that every prison, every jail properly feed inmates, it's not a federal duty to come in and pay for the food if the state or local facilities don't adequately feed their inmates. You make sure they comply with their state duties. So I know there's disagreements on the solutions, and the easiest thing is just let the federal government pay for it. But states and local government have an obligation to make sure the system works by having people get adequate representation. And I think it is excellent when the national government, the federal government, can and should show the way, just like saying this is what proper nutrition is, and then it's up to the states and local government to make sure it's adequately funded so that we do not have cases like Mr. Crotzer's unfortunate situation arise, that we address that adequately. It just seems to be a question of making sure that that is applied across the country. I do appreciate the witnesses being here, and again, I hope everybody's not going to beat up on the defense attorneys, so many of whom actually do a good job. When I found somebody I didn't think was doing a proper job, they did not handle another case in my court. And we handled all felonies, including death penalty cases. But thank you, Mr. Chairman, for the time, and at this point, I yield back.
Thank you, and I'd point out I don't think my comment should be interpreted as being critical of the attorneys. It's just when attorneys, no matter how good they are, have a caseload way over what a caseload ought to be, they're put in an impossible situation. So your point that the attorneys are doing a good job, I think, is well taken. Gentleman from Michigan, we're joined by the chair of the full committee, and as he's recognized, if the witnesses will come forward and take your seats. Gentleman from Michigan, Mr. Conyers.
Top of the morning, Mr. Chairman. I'm so happy to be here. We've had the beginning of this hearing on March 26th. This is June the 4th, and here we are back looking at it again. We had former Mayor Dennis Archer, David Carroll, Nancy Deal, Erik Luna, Regina Thomas, Robin Dahlberg. So there's been a predicate for this, and I'm so glad that Judge Gohmert, our ranking member, is back again with us, working on how we can work this thing out. And I see the senior member of the committee, the ranking member, Bob Goodlatte, is here. And we're joined by one of the newest members, Mr. Paralucci, but he was an attorney general from his state, and we're glad that he's here too. Now, what are we here for? To make the adversarial system the basis of our judicial process a better one. Now, this is constitutional. What part of the Constitution does this appear in? I said, what part of the Constitution does this appear in? Sixth Amendment. All right. Sixth Amendment. Thanks for your attention. I want to yield time to the newest member of this committee that I can think of, is Mike Quigley. I want to give him some of my time, Mr. Chairman, if I may.
Gentleman's recognized.
Thank you for yielding. Thank you, Mr. Chairman. I would like to add something I think that's a little timely in notice that affects this issue. Chairman's correct. I am the newest member of this committee, second newest member of Congress. but I spent 10 years in Cook County with a ringside seat in the criminal justice system defending people, and watched the extraordinary overload of cases that the public defender's office had there. Yesterday, I think much of that came to a head. A very good friend of mine became the public defender of Cook County the last week I was there, A.C. Cunningham, a former judge. Yesterday, he asked that the public defender's office be allowed to withdraw from all of their capital cases because they have zero money to defend capital cases for expert witnesses, for all the other costs associated with the extraordinary defense that comes with a capital case. To me, that is as good an example of what is wrong with our system right now in providing a fair and just criminal justice system as you're going to find. Third largest county in this country cannot fund capital cases and is asking to withdraw. My first act as a county commissioner was to agree to pay a $36 million settlement to a group called the Fort Heights Four, who were wrongly convicted of a murder case and were, in some cases, minutes from the death penalty. One of them was raped in prison. They were later exonerated using DNA evidence. And what was pointed to was the extraordinary inept counsel that they had. Where we're going from here can only be downhill unless we do something, because the public defenders are overburdened, and at this point, they have no resources to handle our most important cases. Those cases which I think in some respects the public cares about least, they're not always sympathetic people, are the ones that we should hold most important to us if we care about justice. So on behalf of my friend, the Chief Judge of Cook County, our best wishes and hopes during this struggling time. And I just want to thank both chairmen for their indulgence.
I'll put the rest of my statement in the record, Mr.
Thank you,
Chairman.
gentlemen. Yes,
Thank
Mr.
you.
Balance of the time. Are there others that want to make statements? If there, just gentleman from Texas.
Yeah, and I did want to also apologize to the witnesses. We have hearings set at the same time. I've reviewed everyone's statement, and I will be reviewing all the information we gleaned both during the hearing and that you may care to submit after the hearing, but I will end up needing to leave before the hearing's over. Thank you.
Gentlelady from Texas, from California.
Thank you very much, Mr. Chairman. I was just considering whether or not I wanted to go into this statement. Why don't I submit the statement for the record? And you're back. Thank you.
Thank you. Other comments? Thank you. We have a distinguished panel of witnesses here today to help us consider the important issues that are currently before us, and I ask each witness, if possible, to complete your statement within 5 minutes or less. There's a timing device on the table that will start off green, turn yellow when there's 1 minute left, and the light will turn red when your time is up. All of the witnesses' statements, written statements, will be made part of the record in their entirety. Our first witness will be Robert Johnson, who has been a prosecutor for over 40 years. He has been the elected county attorney in Minnesota since 1983. He's past president of the National District Attorneys Association, Minnesota County Attorneys Association, and the Anoka County Bar Association. He's a past chair of the American Bar Association Criminal Justice Section, and a member of the Minnesota National Guard. He graduated from the University of Minnesota with a bachelor's degree and a Juris Doctorate. He's also co-chair of the National Right to Counsel Committee. Our next panelist will be Alan Crotzer. How do you pronounce your last name?
Crotzer.
Crotzer?
Crotzer.
Crotzer. Was 20 years old when he was arrested for a crime he did not commit. He met with his court-appointed attorney for the first time 90 days after his arraignment, and will will hear that story when he testifies. He is now works as a intervention specialist at the Florida Department of Juvenile Justice, encouraging at-risk kids to follow a positive path. Our next witness will be introduced by my colleague from Virginia.
Thank you, Mr. Chairman. It's again my pleasure to welcome back to the committee Erik Luna, a professor of law at Washington Lee University School of Law. He graduated summa cum laude from the University of Southern California and received his JD with honors from Stanford Law School, where he was an editor of the Stanford Law Review. Upon graduation, he was a prosecutor in the San Diego District Attorney's Office and a fellow and lecturer at the University of Chicago Law School. In 2000, Professor Luna joined the faculty of the University of Utah College of Law, where he was named the Hugh B. Brown Chair in Law and was appointed co-director of the Utah Criminal Justice Center. He has served as a senior Fulbright scholar to New Zealand. He is an adjunct scholar with the Cato Institute and a member of the U.S. Chamber of Commerce's Working Group on Criminal Law Issues. In early 2009, Professor Luna accepted a permanent faculty position at Washington and Lee University School of Law, from whence I am a proud alumnus. So thank you very much, Mr. Chairman, and welcome, Professor Luna.
Thank you. Next panelist will be Mr. Malcolm R. Ty Hunter. He has spent more than 30 years working on behalf of indigent defendants in North Carolina. He is the executive director of the North Carolina Office of Indigent Defense Services from 2001 to 2008. Before that, he served as the state's appellate defender from 1985 until his appointment to the Indigent Defense Services. He is currently the executive director of the Center for Death Penalty Litigation, a nonprofit law firm representing capital defendants at trial, appeal, and post-conviction. He graduated from the University of North Carolina Chapel Hill School of Law and served as an adjunct professor at the law school since 1998. Next panelist will be John Wesley Hall, currently the president of the National Association of Criminal Defense Lawyers. He served as deputy prosecuting attorney from 1973 to 79 and has since then been in private criminal defense practice. He's the author of several books and law review articles on trial practice, criminal law, and professional responsibility for criminal defense lawyers. He's a frequent lecturer and expert witness on legal ethics and related matters, and serves as a consultant to the Arkansas Supreme Court Committee on Professional Conduct and on the Disciplinary Appeals Board for the International Criminal Court. He graduated from Hendrix College with a BA and the University of Arkansas with a Juris Doctorate. Final witness will be Justice Rhoda Billings, who received her BA from, was it Berea College in Kentucky, and her Juris Doctorate from Wake Forest University School of Law. She has been a private practitioner, a law professor, and a judge. She is an Associate Justice and Chief Justice. She was an Associate Justice and Chief Justice for the North Carolina Supreme Court. She's been a professor of law for many years at Wake Forest University School of Law, where she teaches criminal procedure and constitutional law. She's been a commissioner with the North Carolina Indigent Services Commission since 2001 and is co-chair of the National Right to Counsel Committee. So we'll begin with Mr. Johnson.
Mr. Chairman, thank you. As a prosecutor under all the case law and standards relating to criminal justice, I know that my duty is to do justice. It's not merely to convict. And in an effort to find justice, I need a competent defender in the courtroom on the case in order to find that. I need that first to protect against convicting innocent people. As you may know, prosecutors don't charge all the cases that come in from the police. 20% of the cases that come in my office, we decline. That's probably a low number compared to other prosecutor offices. And even those that I charge, the 80% of the cases, there are questions that we still have from the police documents that we get. There have been any number of times when defenders have gone out, done their investigation, analyzed the case, and convinced us that there's not a crime that's been committed, and certainly not a crime that we could prove was committed. I need them to protect against convicting innocent people. I also need them to find the proper sentence. Make no mistake about it. Prosecutors' sentence. When I charge a mandatory minimum And in my state, when I charge a crime or plea bargain to a crime, it puts in on our sentencing guidelines box. So as a federal judge once said at the Kennedy Commission hearing in the ABA, if AUSAs are going to sentence, they should get a PSI before they indict. As I need more information about the offender, if I'm going to be able to find the right disposition of the case. Now, most of the people that we deal with are ordinary people who've just done something bad. The truly evil people, the predators, are easy. We just max them. We put them away for as long as possible. But most of the people that we deal with are not. And our challenge is to try to find the right sentence. So I need to have the defender tell us about the characteristics of the offender that enables us to find the right sentence, find the right disposition. And I need defenders to move cases. Now, I'll certainly acknowledge that we have some excellent public defenders in my jurisdiction. I have a tremendous public defender who just headed up our district public defense, went to another district. There just aren't enough of them. There aren't enough of the defenders to be able to deal with it. So that when we don't have enough defenders, as was pointed out in Chicago on capital cases, it paralyzes the system. The system does not go forward. Defenders have to triage the cases that they're going to handle and decline to handle the others. As was pointed out too, defenders are starting to realize more and more their ethical responsibilities not to take on cases that they can't adequately represent. So you see in Florida, you've seen in Massachusetts, you're seeing now in Illinois, where the defenders are saying, we're not going to represent these people because we can't do an adequate job. That paralyzes the system. We have to have good defenders in the courtroom for the reasons that I have stated. As the report amply discusses, the state of criminal defense in this country is not good. It's bad. There is an enormous amount of work that can be done in the states. And we recommend in the report that the federal government contribute to the solution. And I will say that the federal government does fund various parts of the system. The federal government has just put $1 billion on the street for cops. I haven't received any of that money to prosecute it. The defenders haven't received any of that money to defend it. So we're going to have an influx of cases that we're going to have to deal with. We need balance in the system. We aren't providing enough balance. I pick up a bit from time to time. Drug prosecution, I get federal money out through the Burn Grant, through the state to my office. I've picked up over $500,000 over the years. In all candor, a piece of that should have gone to the defense system. We should, and I understand that's a state responsibility to allocate some of that burn money, or at least is in my state. But we have to recognize that this is a balanced system, and if we're going to do justice, it's important that we do balance it. Now, at some point, the states have to come to terms with the over-criminalization of behavior. The criminal code in my state, Minnesota, has gone from the time I've been a prosecutor from 35 pages to over 200 pages. When I started this work 40 or so years ago, I had less than 100 cases. In 2006, I had 1,800 cases. So we have to come to terms with this. And I think the recommendations in the report are well taken. Funding defense and a National Center for Public Defense. Thank you, Mr. Chairman.
Mr. Crotzer.
Good morning, Chairman.
Good morning.
Committee members. And I just want to thank God for being here this morning. I didn't think I was going to make it. I only got in around 2 o'clock this morning. My flight was delayed so much. So if my eyes are red, it's because I didn't have much sleep. I did submit a written report, and I know everybody should have one. But I want to tell you real quick what really happened to me with my own words out of this mouth. In 1981, I was convicted of 3 counts of armed robbery, 1 count of attempted robbery, 2 counts of sexual battery, 2 counts of kidnap, 1 count of armed burglary, and 1 count of assault with a deadly weapon. I was tentatively identified by one of 2 rape victims as assailant. I was said to be 6 feet tall, light complected, weighing 200 pounds. I was 5'5", weighing 135 pounds. As you look at me, you can see I've never been light skinned. So, you know, but all this points to the fact that I was convicted 10 months later, sentenced to 130 years. I spent 24 years, 6 months, 13 days, and 4 hours wrongly convicted. And it wasn't for the grace of God and DNA testing, I'd still be rotting away in a South Florida prison for crimes I didn't commit. It took me 20 years to writing letters to everyone, even the person that prosecuted me and the lawyer that became a judge that handled my case, who can't remember me. 20 years of writing to people everywhere all across the nation to finally find someone to take my case. 1,200 miles away in the city of New York City, David Mincho, Sam Roberts came to my rescue. 2 young men that one was just an intern and one was just an attorney for a couple of weeks. They saved my life. It took them 3.5 years to get me out. That's what you call competent representation. Why did I not get that before then? No one looked at my alibi witnesses. No one looked at the fact that I didn't fit the description. At least my attorney didn't. The serologist report was blotched too. The serologist report proved that I couldn't have been the perpetrator of the crime. And yet I spent more than half my life in prison. My whole world is turned upside down. And I'm not the only one. I was number 5 in the state of Florida, 173 in the country. I haven't been out for 3 years and 4 months. There are 10 in the state of Florida, DNA exonerees, and 234 in the whole country. That's 1 per year for the existence of this country. 1 is too many. The system is broken. It failed me from the beginning. Why? Because I was indigent and convenient. This has to stop. And the only people who can change that is basically people in power, people on this committee, no matter what your political party is. People are dying in there. I represent right now in my heart, I represent Frank Lee Smith, who died on death row, the first DNA exoneree in the state of Florida. He died on death row before he was DNA exonerated. He was exonerated after his death. I represent him today in my heart. And there are others. And all I'm asking is that you read the report and try to help us. 1 is too many. That's all I have to say.
Thank you. Thank you. Professor Luna.
Thank you. Thank you, Congressman Goodlatte, for the very kind introduction. Chairman Scott, Ranking Member Gohmert, and members of the committee and subcommittee. Thank you for the opportunity to speak today on the subject of indigent representation of counsel. Let me begin by reiterating my firm belief in the Sixth Amendment and the constitutional duty of the states to provide competent legal representation to indigent defendants whose liberty the prosecuting jurisdiction seeks to deprive. It is as true today as it was when Gideon was announced that defense attorneys are necessities, not luxuries, in the criminal process. One of the documents that inspired today's hearing, the report of the National Right to Counsel Committee, provides a comprehensive review of indigent defense in jurisdictions across the nation. I will not reiterate the troubling narratives it provides, as my fellow witnesses and the report itself can do this with far greater eloquence. I simply pause to note that the problems detailed in the report are deeply disturbing to me, and I suspect the sentiment is shared by most in the room, regardless of political party. The real issue is not whether a so-called constitutional crisis exists, but what entity created the dilemma and what should be done to resolve it. In other words, questions of responsibility and remedy. Like previous works, the report sets out a series of recommendations to deal with the problems of indigent defense. Almost all of the recommendations are unobjectionable, if not laudable, particularly those that call upon the states to fulfill their constitutional obligations by providing adequate funding. Not only is it constitutionally required that the states pay for these expenses, it's altogether fitting. After all, the states and their agents are the ones who set the entire process in motion and have made all the choices that have resulted in today's situation. As a matter of federal constitutional law, the states have no obligation to criminalize and punish any particular behavior, nor are they required to arrest and prosecute any given individual. But when jurisdictions choose to employ their awesome power to deprive individual liberty, they have the absolute duty to comply with the U.S. Constitution, including the Sixth Amendment. In a very real sense, the states have brought any crisis upon themselves through overcriminalization. And to be sure, they have the power to remedy the situation by parsing back their bloated penal codes and reducing lengthy sentences, and by being more prudent in the enforcement of criminal laws on the streets and in courthouses. Indeed, there should be no doubt that the relevant jurisdictions can provide the funds for competent indigent representation, as demonstrated by the disproportionate resources provided to prosecution offices and law enforcement agencies, and the vast sums the states spend on legal work and programs that are not constitutionally required. Now, I won't belabor the two primary arguments regarding federal involvement, the principles of federalism and the potential for perverse incentive structures, as I testified about these concerns at the last hearing, and they are laid out in some detail in my written testimony today. In a nutshell, federalism, which is in the text and context of the nation's charter, limits federal power and cautions against interference with the core internal affairs of the states, including state criminal justice. As the Supreme Court has said, constitutional concerns are raised whenever Congress affects a significant change in the sensitive relation between federal and state criminal jurisdiction. Federalism has many values, including protection against the dangers that come from the concentration of too much power in too few hands. Federal funding of state indigent defense also raises policy issues, especially the specter of moral hazard, an economic phenomenon that was once described as the distortions introduced by the prospect of not having to pay for your own sins. If a given state does not bear the full costs of its criminal justice decisions and instead is able to externalize a politically disagreeable expense on another entity, state officials may have little incentive to temper their politically self-serving decisions that extend the criminal justice system. In a worst-case scenario, those states that have met their constitutional requirements may be tempted to skimp on their budgeting for indigent representation with an eye towards receiving federal support. I should also mention that I have some concerns about the proposed National Center for Defense Services, the bureaucracy that would set policy and control and dispense federal funds. Although the proposal is extremely well-intentioned, caution is warranted in creating any federal body with such powers outside of the constitutional framework. Government bureaucracies tend to be acquisitive, monopolistic, and they seek to maximize their funding and expand their powers. They also have a tendency towards entrenchment, and they create agency costs, serving the self-interests of bureaucrats rather than the principles, the American taxpayers. Now, although federal involvement in state indigent representation is problematic on a number of grounds, I will not lose sleep if Congress were to create the National Center for Defense Services. I am, in fact, more troubled by the prospect of becoming an involuntary stockholder of General Motors. But before acting, I would simply recommend that Congress take into consideration all constitutional values at stake, including federalism, and the unintended consequences and equity of absorbing the costs owed by the state that in all good conscience they should pay. Most of all, I hope Congress will consider measures that do not raise the same type of constitutional and public policy concerns, a few of which I mentioned at the end of my testimony, my written testimony. Again, thank you for the opportunity to speak today, and I look forward to answering any questions that you may have.
Thank you. Mr. Hunter.
Thank you very much, Mr. Chairman. Can you hear me? Hello. Good morning. Is this working? Do I need it? The light is on. Now you can hear me. I need to have it a little closer. Mr. Chairman, members of the committee, thank you very much for the opportunity to be here. I suppose on this panel, I'm the career public defender. Mr. Governor, I'm the one who should defend the lawyers who do this work. I've devoted my whole career to it. And there is no question but what there are lawyers in every state and all over the country who are doing great. Some people are doing heroic jobs, and a lot of people are doing good jobs. But I think the report is correct in that, in general, the system is not working well for a combination of circumstances. I think money is probably the biggest reason. I also don't disagree with Professor Luna that this is the state and the local folks' problem in a lot of respects, but we're here. The states aren't doing it. We don't seem to have a good way to force the states or make the states see their responsibility in a way that they provide adequate funding. And adequate, I would say also standards are just as important as funding for this problem. And we're in a situation where we are, in fact, sending lots of federal money in. There's lots of federal money has gone into North Carolina, and we're like Minnesota. I stopped even applying for Burns grants years ago because we never got a sniff at that. The great majority practically all of that money goes to prosecution and to law enforcement. And so we're not living in a world where the federal government is not involved in state criminal justice. Maybe we should be, but right now the state's thumb is on one side and not the other. And so if we get out, if Mr. Luna's idea of the way government should work prevails, then I have no complaints. But until that happens, I think the defense function should get their fair share, or at least a fair share. And so far, they're certainly not. I want to follow up just briefly on Mr. Crotzer's story. That is not a unique story. I mean, there are 5 or 6 or 7 people convicted of first-degree murder in North Carolina. Actually, a lot of them had good lawyers. Some of them had terrific lawyers, but were wrongly convicted, and only through DNA years later did we find out that, in fact, they were not guilty. I think what all of us need to remind ourselves about DNA is that DNA is just a window to allow. What's more important than DNA is what's the evidence that allowed judges and juries to convict somebody and find someone guilty beyond a reasonable doubt. Forget about the DNA. All of those were cases where there shouldn't have been evidence that would prove their guilt beyond a reasonable doubt. You shouldn't have to prove you're innocent. The state has the burden of proving you're guilty. So we have hundreds of cases where juries are convicting, prosecutors are prosecuting, where in fact they've got the wrong person. And so we need to be aware of that. And of course, better counsel will be a very important part in trying to improve that situation. But DNA is not the answer. DNA has given us a window into a criminal justice system where we're making mistakes, not most of the time. It's in a small group of the cases. But we can minimize those mistakes, I think. And we need to look at what's the evidence, what are the commonalities of the evidence that we're convicting people on that later DNA is showing us that we made mistakes. And so I hope we will look at that. And I hope if the federal government gets involved in defense, that you will not just send money down to North Carolina and let somebody down there decide, willy-nilly how to spread it out to make up for the gaps in what the state should be doing. I think the appropriate role for the federal government is limited, and it should be to encourage innovation, to encourage improved quality. I think any money that gets sent down should be tagged so that we're not paying for what the state should be paying anyway, or allowing the state to shift funds to highways or something, all of which we need in North Carolina, by the way. But that improves the situation we've got right now. And I think there are lots of opportunities for innovations and for quality that could come from outside funding. And I'll give you one example. It's in my written materials. An LEA grant was awarded to North Carolina in 1980, and we started the Appellate Defender's Office. That was the first statewide defender we had in North Carolina. We had a few local public defenders, but we had no statewide defender office. It funded that Appellate Defender's Office for 1 year. I think it cost about $350,000 back in 1980. That office was evaluated after that first year. The state picked up that office, decided that was an agency that was worth the state funding, and it's been going and has provided excellent representation for indigent people on appeals for 29 years now. And in fact, I think the success of that office helped create an atmosphere where when we tried to form the Indigent Defense Services in 2000, it was acceptable to the legislature and to the courts and to the bar because of what we had done in the Appellate Defender's Office. So that was a small seed money, if you will, contribution by the federal government, which was limited in time, 1 year, and then the states decided, is this a service that's worth picking up or not? And they did pick it up, and I think it's really been a part of the reform movement that we've had in North Carolina, where we have improved our work. Thank you very much.
Mr. Chairman, I'm here on behalf of the National Association of Criminal Defense Lawyers, and we are the organization that represents the mission of the United States criminal defense lawyers to ensure due process of those accused of crime. We have 12,000 direct members and approximately 40,000 indirect members through our state and local affiliates. And we are committed to preserving fairness within the criminal justice system. The Sixth Amendment to the United States Constitution guarantees to every accused person the right to effective assistance of counsel. And it is one of the hallmarks of American justice. It's also a core value of our constitutional guarantees because it is in the Constitution explicitly. Defense counsel is recognized by the Sixth Amendment. The court is not, the prosecutor is not, but defense counsel is. Criminal defense lawyers are, of course, the natural defenders of all these rights. As already noted by the chair, 80% of all persons accused are represented by appointed counsel. And public defense is, in fact, the backbone of American criminal justice. And public defenders, I submit to you, get no respect at all. I do a fair amount of post-conviction work, and I ask the clients, who represented you at trial? And they said, I didn't have a lawyer, I had a public defender. And that's an appalling comment at what people convicted of crimes think about their representative. They shouldn't think that way, but they do because appointed criminal defense lawyers are just overwhelmed in their work. They have a constitutional and ethical duty not to take any more cases when they get overwhelmed. In Louisiana, lawyers in some counties have sued the court or the state to say, I cannot take any more cases. I need help. I'm overwhelmed. My clients are being convicted because I can do nothing more to defend them. When I have to, as the case in Louisiana, New Orleans, for instance, when they have 19,000 cases, misdemeanor cases per public defender. That's 7 minutes a case. You cannot represent somebody in 7 minutes. And the example of the death penalty that Mr. Quigley raised, if the state wants to have a death penalty, then they have to pay for it. They have to pay for the prosecution, they have to pay for the investigation, and they have to pay for the defense. And 998 out of 1,000 death penalty cases have appointed counsel. Occasionally somebody can afford to pay for counsel, usually they cannot. The soundness of our entire system depends upon the accuracy of results. Mr. Crotzer's case points that out. If the wrong person is convicted, that means that the perpetrator is still on the street. While he spent 20 years in jail, the guy that actually did it is still out there. He may have been arrested later for that crime, but maybe not. But all this erodes public confidence in the system of justice. And I agree with Mr. Gomert that there are, in fact, good examples. We should study those examples to learn from them. But every state manages its own public defense system, and some have no system at all. But those systems, the good systems, are the exception rather than the rule. I don't think that even new money is necessarily required. Just require that when you give, say, $1 million for defense, or excuse me, $1 million for prosecution, that some percentage of that should be guaranteed for the defense, be it 10%, 5%, something, so that at least we see how it works at the state and local levels, because they will take all this money and they'll put it all in prosecutors, they'll put it all in investigators, and give nothing for defense, because defense is secondary to them. But as I've said before, it is a core value of the Sixth Amendment. And don't let it become an empty right. It continues to be an empty right in some states, and it should stop being an empty right. Thank you.
Good morning, Chairman Scott and Chairman Conyers, and distinguished members of the subcommittee. Thank you for the opportunity to comment on the issues that are raised by the report of the National Right to Counsel Committee, of which I am a member. Having listened to the statements of the members of the subcommittee and of my co-witnesses, I've decided to depart completely from my prepared remarks, in part because I think everyone here expresses the same agreement that there is a serious problem a real crisis in indigent defense across America. A system of criminal justice that does not convict the guilty fails society, because it leaves on the streets those people who have committed crimes and will probably commit them in the future. But a system of criminal justice that convicts the innocent, does not exonerate the innocent, is totally contrary to our entire American view of justice. And we know that people are being convicted who are innocent of the crimes. The rate at which our citizens are being incarcerated, or even if not incarcerated, are given criminal records that interfere with their ability to find employment and earn a living for themselves and their dependents, a rate that is the highest of any nation in the world, is a national disgrace. I have some statistics on a report from the Pew Center on the States. In their report released a little over a year ago, entitled "More Than 1 in 100 Adults Are Behind Bars." That report also deals not just with the ones who are behind bars, but those who are under some present supervision in the form of parole, probation, or incarcerated. In my state of North Carolina, 1 in 38 adults are under that kind of control. In the state of Virginia, it's better. It's 1 in 46 adults. In the District of Columbia, it's 1 in 21. In New York, it's 1 in 53. In Texas, it's 1 in 22. Those are people that society has either taken away their liberty or has given them a mark that prevents them from gaining employment. Are we as a nation that bad? I don't think so. What we have had is an explosion in the kinds of behaviors that are made criminal. What we have had is an explosion in the length of sentences that are imposed on citizens who are convicted of crime. And what we have had is a system that does not protect from a finding of guilt those people who are wrongly accused. Yes, there are dedicated criminal defense lawyers across this state and this nation. But as Bob Johnson told you, we don't have enough of those people, and the people who are dedicated to the defense function are burned out in a very short period of time. They have so many cases, they can't do a good job no matter how dedicated they are, because they simply don't have the resources, they don't have the time, they finally give out of energy. I'm proud of what North Carolina has done, and Ty has been a tremendous asset to the state and was our first director of the Office of Indigent Defense Services, set in place a number of policies and a number of studies that have, I think, moved North Carolina very far ahead. But we are a long way from having solved the problem, because it is, in large part, a problem of having the money and the time to give to those people who are providing the defense the things that they need in order to succeed. The training. In my statement, you will notice that my experience as a lawyer was that the first time I was in court, shortly after I graduated from law school, I defended a person charged with murder. My husband tells, and in my statement I tell about my husband representing a defendant who was charged with common law robbery, something that had a potential sentence of 20 to 30 years. The judge pressured him to accept a plea of guilty, his client to accept a plea of guilty. He refused to. That pressure still comes from some judges. We have to stop it. The judge says, if you don't accept the plea, I'll sentence him to the maximum for whatever he's sentenced for or convicted of. Yeah, he was convicted of simple assault and got 30 days. Judge says, okay, now it's time for me to set your fee. 4 days of trial, $75. My husband turned and walked away and says, I didn't try this case for the money, Your Honor. You can keep your $75. Those are the kinds of things that we see throughout the system, time after time after time. What we're here today for is to talk about what can we do about it. All governments are struggling with budgets. All governments are trying to spend their money wisely. How do we get the attention of state legislators who are struggling with budgets to see that this is an important priority? And there's where I think, in addition to the other suggestions that have been made, that we can have the federal government provide leadership in showing the states, bringing to their attention the problems that we have in indigent defense and assisting in getting them to recognize the problem and that this is a more serious problem than some of the things that they're using their money to support. Thank you.
Thank you. And now we recognize ourselves for under the 5-minute rule. Justice Billings, you're not on the Supreme Court now, is that
correct?
Right? If counsel was so ineffective, how do you get a final judgment? Why isn't the Supreme Court overturning convictions on the basis of ineffective counsel?
There are, I think I would give two answers to that question. One is that the United States Supreme Court has established a standard for ineffective assistance of counsel.
And does that mean that that burden has not been met, notwithstanding the fact that you can show that your attorney was asleep during the trial?
You have to be able to show not only that counsel was ineffective, but that in the absence of that ineffectiveness, the result would have been different. And that's a very difficult thing to show when you don't have the evidence that backs up that is, you don't have the evidence that would have been presented to the court had counsel been effective. The other thing, of course, and the second sort of answer to your question, Chairman Scott, is that the appellate courts really are not able to substitute their judgment for that of the jury. They don't know what evidence was out there but not obtained, and they don't have the ability to say, well, I don't believe this witness who is an inmate who testified that the defendant made a statement confessing his guilt, when in fact that inmate who was the witness against the defendant was only attempting to curry favor so that his sentence might be reduced or he might get some benefit from the state. So there's no way that really the appellate courts can rectify the deficiencies that result from ineffective assistance.
Well, Justice Billings, let me ask you another question, just a kind of philosophical question. Is a guilty person entitled to a fair trial?
Yes.
If you're on appeal and have to show that the result would have been different, that is, that there would have been an acquittal, if he's in fact guilty, you probably wouldn't have gotten an acquittal if you had a fair trial. And therefore, how on appeal can a guilty person be guaranteed a fair trial if on appeal the question is he guilty?
Well, we don't know if he's guilty if he was not given a trial in which the
But if he can't prove his innocence on appeal, that is, that if you'd found the evidence, they would have found that I didn't do it. If he in fact did it.
Well, the problem, I think, I'm not. I guess maybe I'm not quite following the question.
Well, if he did it, you're on appeal. If they found out any evidence they find, it would only confirm the fact that he in fact was guilty.
But you see, the appellate court doesn't get additional evidence. The appellate court.
Whatever evidence they got, it wouldn't have been a different. It would not have been a different result, and therefore, under the present system, a guilty person really isn't entitled to a fair trial, because when he gets on appeal, he can't prove his innocence. He can't prove that it would have been any different, because if he had gotten a fair trial, he probably would have been found guilty.
That's presupposing that the person is guilty, but we don't know until we've had a fair trial whether he's guilty.
That's true. But if he is in fact guilty, according to this scenario, he really isn't entitled to a fair trial, because on appeal, unless he can show some difference, that is, he would have been acquitted, he shouldn't have been acquitted. He was guilty. And so they have a sham trial, he gets on appeal, and he's really in a situation, and like you're right, you don't know whether he's guilty or not, so if a guilty person isn't entitled to a fair trial, you get on appeal, an innocent person is stuck with having to prove his innocence.
Chairman, I would say that everyone is entitled to a fair trial. If as the result of that fair trial the person is found guilty, well, absolutely they should suffer the consequences of their guilt. Now, one of the things that we have seen happening across in some of the states, and again, making reference to my own state of North Carolina, we have an actual innocence commission that has been put in place as the result of the number of exonerations that we have been seeing, primarily as the result of DNA testing. Now, those commissions are looking back at the question of, was this person's trial fair, and is there other evidence?
That is to show whether they did it or not, whether they are in fact innocent.
Whether they are in fact
and if the person is in fact guilty,
they would not recommend that it be reviewed further.
And if the person on appeal cannot represent as part of the allegation that I didn't do it, if he in fact did it but just didn't get a fair trial, there's nothing there for him. He's not entitled, a guilty person is not entitled to a fair trial.
I still say that our Constitution entitles everyone to a fair trial.
Well, in the present system, there's nothing to guarantee that for a person who is in fact guilty.
There is nothing to guarantee that a person who is in fact guilty will not be found guilty and punished.
Even if the trial is not fair. Because when he gets on appeal, he did it. So the fact that he got a unfair trial, there's no reversible error for a guilty person being convicted in an unfair trial.
I cannot say that it is not. There are a lot of cases that are reversed on appeal, even though the defendant may be guilty. The appellate process is not to determine guilt or innocence so much as it is to determine whether there was a fair trial. And if some defect in the trial violates the rules, then the appellate courts will reverse and send it back for a fair trial to determine whether the defendant in fact is guilty.
That's the way it ought to work, but as you've heard, unless you can, on ineffective counsel, you have to show the result would have been different, which only an innocent person can do, not a guilty person. So if you have someone like Mr. Crotzer who was innocent, he can pursue his case because he was in fact innocent. Had he in fact been guilty and gotten that kind of representation, what would have happened?
The question.
My time has expired. I've got a bunch of other questions. Let me go to the gentleman from Michigan, Mr. Kanye.
The present chair of the Crime Committee and Judiciary is the finest one that I have ever worked with since I've been on the committee, which goes back an incredibly long amount of time. But he also is a psychological student, and he uses reverse psychology in some of his questions, which could confound the normal mind. I'm used to it, though. I want to commend him for these series of hearings that he's held. This is an enormous subject, and I am not concerned with the media, except there is only one reporter in the Judiciary Committee during this hearing. Chairman Scott made me feel a lot more comfortable when he told me they're all looking at it up in the gallery in their offices. I want to believe that too. And that puts a finger on the problem, doesn't it? This is not a sexy subject. Who wants to listen? Hey, let's look at all the talking heads and drama shows and crime shows and law, how prosecutors bust criminals, all that going on. And here we're talking about a whole history of a serious constitutional problem. And we scrape up one reporter. And I commend all 6 of you this morning, because we've been extremely legalistic, and I'm so glad that nobody has raised the question of race or racism. I'm proud of you. I'm not raising it either. I want to keep this discussion clean of that. But it occurred to one smart aleck staffer that the reason for most of this is race. So I commend all of you for wanting to do something about it. We apologize to Rhoda Billings. Her sign should read Chief Justice Rhoda Billings. Since we're putting on she's a former justice, why don't we put on former Chief Justice? And she's done all of you have done such a commendable job. Professor Luna deserves a hearing on the constitutional questions that he raises. That could be a panel of a serious discussion, because I respect your integrity and the way you posed not only the problem, but the solution to the problem. All of you have done such a great job. Now, the question is, and I think it was Malcolm Hunter who put it succinctly, it's not just funding, but how do we revisit the standards and make them workable? I think that's the crux of which I hope our chair will continue these hearings. Now, this raises another subject for the committee. This is one part of the Constitution that is failing to uphold its commitment. I mean, everybody, I walk around with a Constitution in my pocket. This thing is failing. We're failing miserably. And this is the first major effort to redress it. And so one of the questions, and we're going to be in contact now. You're part of our extended legislative committee now. There are a lot of, there's so much going on that we could go into this further, but it's a huge undertaking. You could put another subcommittee. We could create another. He's got so many problems: disparity, the state of the prisons, the fact that many people are further criminalized after they're incarcerated. He's got stacks of stuff. And so we've got to look at this as effectively as you brilliant people who've dedicated your careers. Johnson could have, all of you, could have gone on into much less trying aspects of the law, of the practice of law, and yet you're here. And that's what makes me so very proud of you. We've got a huge job to do, and when we do it, we make the Constitution believable. I close with this thought. I keep asking myself how people in this country, the greatest democracy, wealthiest, most powerful that civilization has ever recorded, and yet you have an election and 12% of the people even bother to cast a ballot. Some of them, people who would have had to pay with their lives to try to cast a ballot not that long ago. And I think that it goes, Professor Luna, into making people believe that this all amounts to something. This is one of the things I'm inquiring into. Why didn't you vote? Well, we like you, Conyers. We know you're going to get reelected. And, I was busy. I'm out of work. I'm being foreclosed on. And so this is plays a much larger role in the psychological dimension of our citizens who say, vote for what? We got a prison-to-pipeline system going in nearly every state in the union. And they're not all bad people or sub-Rosa Klansmen or people with a fanatical racist attitude. Look, folks, it's just the system, Conyers. All these people we're bringing into federal court in your city, all punks on the corner, you arrest them one night, there's another group there that are back selling narcotics, and they'll be in the next week, they'll be brought in chains. And in your heart, you know they are done for. They got the odds against any of them. And it's not that they're all innocent or that they were framed, but the system goes for, someone said it, over incarceration, over prosecution. Look, we caught this guy on the corner, and you know what? And with disparity kicking in, another one of his problems, he's going to get the max. First time. Sure, he violated the law. But those of us who make the law have to ask the question, is this what this country is really all about? Is there any way, Luna, that we can devise a system that doesn't coddle criminals or allow us to be told that we're soft on crime, but yet can understand the dimensions of a community where you got 70% of the people unemployed? They talk about a 9% unemployment rate. Are you kidding? And the people that are driving around and looking flashy, they're all violating the law hand over fist, and everybody knows it. And so kids know. We've got graduates now that can't find a job. People are saying, and it really hurts, I'm not going to college. What's the difference? I can make as much money not going to college. What do I need a degree for? It's incredible that we could have come to this situation, and yet, as you say, we are the primary shareholders in General Motors. And at the same time that they're closing plants in Detroit, Hamtramck, Trenton, and moving out of the country with billions of taxpayer dollars. So I can't tell you how important your insights are to me and how important this committee is to me.
Gentleman from Puerto Rico.
Thank you, Mr. Chairman. I commend you as well. And the first thing I'm going to say is that it's so much easier for elected officials to talk about law enforcement as opposed to the rights of the accused. And that's why this is it's a tough one for many. But all of us who have been officers of the court know that this is about justice. It is about the adversarial system that we are supposed to have in America. And the way it works is by both sides having access to competent counsel, the prosecution as well as the defense, the accused. Right now, it is clear that this is not working. And one thing that was mentioned in here, I believe it was, well, both Mr. Johnson and I believe also Professor Luna, is that we talk about funding, we talk about perhaps this is not a matter of spending more money, but we have to also look for a balance in the way that the Department of Justice uses its resources. There is a wide range of federal programs assisting prosecutors, assisting police, in prevention as well. So we have to then determine ways in which we can use federal funding to improve the way we go about complying with the Sixth Amendment. It could be in the area of standards. It was mentioned by Mr. Hall. It could be in the area of innovation and quality, trying to spur that. Perhaps we're talking about formula grant programs. It could be discretionary programs, but we have to be creative. We have to deal with this. We cannot simply let it continue happening because it ends up with a travesty of justice, like in your case, Mr. Crotzer, and in so many others. I wonder then, what's the best way of dealing with this from the point of view of the federal government and the point of view of limited federal resources? So I just throw the question, and I assume that any of you, particularly Mr. Johnson or Professor Luna any of you could address it. Creative ideas, ways in which we can come up with programs at the federal level to improve the way that we're handling this, because frankly, it is really, really, really disturbing, and it should be disturbing.
Mr. Chairman, member, I raised that, and as you've described, I think it's a very important issue that when you're considering funding some aspect of the state criminal justice system, that there be direction to the Department of Justice, if we're routing it through justice, that that be parsed to all parts of the system, that you can't, as you very accurately recognize, that you can't fund one part of the system and continue to have a system that's going to deliver justice, because the other parts have to also come into play. You can't fund specialty courts unless you're also going to fund the defense aspect of the specialty courts. You can't put enormous amount of money into drug interdiction if you're going to deal with the drug problem through the criminal justice system. You can't just provide that to drug task forces and to prosecutors to prosecute that. You also have to provide funds, if you're going to have a system of justice, to the defense side too, so that we can effectively deal with those, and perhaps not quite as harshly as we historically have been doing.
Mr. Chairman, I would suggest that you look at the Administrative Office of the Courts. They fund the federal defender system, and the federal defender employees make as much as the U.S. attorneys make. They're adequately staffed, they have caseload numbers, and when they reach a caseload maximum, they put other people on staff, the same as the U.S. attorney does. Just look at that system. It's administered throughout the federal government by the judiciary on the defense side, but the Department of Justice has an equal balance through the federal defender. The problem is what happens when it gets down to the state level. You give the money to the states, and they get whatever number of millions of dollars for prosecution. None of that goes for defense, and that just gives another overwhelming advantage to the prosecution. Some part of that money could be delegated to the defense, so you're not spending any more, but you're requiring them to guarantee the Sixth Amendment right to counsel in these new prosecutions that they're trying to instill.
I would commend Chairman Conyers for his words, and just to add a little, this is to add on to what he said. If you placed a prison wall around North Dakota, South Dakota, and Wyoming, and counted every person as an inmate, it would not equal the total prison and jail population in America. And only to get, you'd have to add American Samoa, Guam, and the U.S. Virgin Islands as penal colonies for it to get very close. That's the problem, is we are looking, obviously indigent defense, and as was said earlier, is constitutionally required. There is no doubt about that. But unfortunately, it is at the very end of the line. There is a lot that happens before then to lead to this problem. Overcriminalization is a real problem. The use of, the abuse of the criminal justice system, the incentive structures that police and prosecutors have to arrest and to prosecute. Those are very troubling in our adversarial system. In terms of what Congress can do, I think there are many things that it can do that are consistent with the Constitution. I would throw this out. I know this won't make me very popular with law enforcement and the prosecutor's office, but one possibility is to simply end federal funding, end the burn grants, which have, among other things, led to the scandal in Tulia, Texas. And that is a possibility. That is a very easy way to end disparity. I understand that's probably unlikely, given the constituents and their desires for federal funds. I think a way forward that would be is very plausible is for the federal government to be a role model. The federal criminal code, if you want to call it, and it is no criminal code. It's spread throughout the U.S. code. Contains more than 4,000 different provisions that are punishable as crimes. That is quite simply ridiculous. Mandatory minimums, which are being addressed by members of this committee, should be looked into and I believe eliminated. The U.S. sentencing guidelines are absolutely indescribable, truly indescribable, and they should be looked at as well. And I would advocate your support for Senator Webb's call for a study commission on the criminal justice system as a whole. Because again, indigent defense is constitutionally required. It is truly, we should be outraged that the states are not meeting their obligations, but it's part of a larger problem as to why, at the end of the day, they are not getting representation.
Can I use a bit more of my time? Actually, I think it expired long ago, Mr.
Gentleman's
Chairman.
time has expired. Gentleman's given an additional 2 minutes.
Just a variation of your proposal on the burn grants could be that you track caseloads, you track what's happening, and then you condition this funding upon complying with the constitutional requirement and improving upon your record, tying one thing to another. That could be an avenue. I wonder, are there recent studies comparing the conviction rates and lengths of sentences between defendants represented by appointed counsel as opposed to those represented by privately hired attorneys? Are there any recent studies? Because if not, the federal government could also, Congress could provide some funding to conduct them. But do you know of any?
I personally don't. Maybe Chief Justice Billings might have heard of something.
I'm trying to remember, and Ty, maybe you can help me, that I think in some of the studies that Margaret Gresham from your staff is conducting, that there is some information on that disparity in the study that she did, but I don't have it at my
Which way is the disparity?
That those who are represented by private counsel are in similar situations get much shorter sentences, come out with a much better result. But I really can't support this. Is just something that's a memory of something that I've read in one of the an effort that the IDS in North Carolina has conducted, but I can't be sure about it.
Mr. Chairman, for a minute.
Puerto Rico yield.
I yield.
I'd like to put this on the record because I'd like you six to help me develop it. We've had all of you here. I'd like to invite some people that may have a different experience and even a different view. I remember Reed Walters, the district attorney from Jena, Louisiana, in September 3 years ago, who went to a school there and he lectured to students about their nonviolent protests. And he said, I can be your best friend or your worst enemy. I can take away your lives with a stroke of my pen. I'd like Attorney Walters to be a witness at one of these hearings. I'd like to have the U.S. Attorney for the Eastern District of Michigan be a witness. And I'd like to, I think we should entertain with the openness of which this committee operates, people who may have a legitimate different point of view from what's been expressed here. I think it's important that there's There are some people who seriously and honestly believe that locking them up and throwing away the key apply to as many people as we can get our hands on. And I think there ought to be a hearing of that point of view, just to see, get a feel of where we are, Chairman Scott.
Thank you. The gentleman's time has expired. We'll start another round. And Mr. Hunter, could you describe the agency that you head right now? Is it a support group, or do you provide actual court representation?
The Center for Death Penalty Litigation is a nonprofit law firm. We actually litigate. We represent clients at trial. And
just for death penalty? Just
for death penalty cases. Prior to that, I was the director of the Office of Indigent Defense Services, which Chief Justice Billings was a commission member, one of my bosses in that. And that was an administrative office that oversaw the provision of indigent defense for people all over North Carolina.
Now, do you have public defenders as opposed to court-appointed attorneys?
We have a mix. We have public defenders in about 40% of the state, mainly where we have our larger towns, and then we have an appointed list in our more rural areas in North Carolina.
And do you provide resources for attorneys, education, professional CLEs and that kind of stuff?
We do provide training. We have manuals, that we make available actually free of cost. You can download them on the from off the internet.
Now, how much does that service cost? One of the things that occurs to some of us that a resource like that statewide would be better than trying to have each county figure out what they're doing, or even a national, so that each state doesn't have to replicate the same kind of resource. How much does it cost to keep the Services Commission up and running?
I think, well, the cost of our office is, I don't know, is about maybe $1 million or $1.5 million. The total cost of indigent defense in North Carolina is, I think, around maybe a little bit higher than the middle of the road. If you look at cost per citizen for indigent defense and you look at the 50 states, the last time I looked at one of Mr. Spanchenberg's rundowns of that, we were a little bit above the average. We were in the 20s among the 50 or 51 jurisdictions.
And how much money was spent?
I don't remember. Well, we
are looking for what portion of the defense cost was spent on the Indigent Services Commission staff?
Well, less than 1%.
Okay. Mr. Crotzer, how long after the your conviction, did they test the evidence for DNA?
Approximately 23 years.
Why did they still have the evidence?
Well, they thought they didn't. My evidence was found in a FDLE crime lab in the basement in a file cabinet where the maintenance man probably was a little too lazy to destroy it. And it sat there in a climate-controlled environment, 5 microscopic slides.
And did the DNA point to the person that actually did it?
What the DNA did was totally exclude me. My lawyers told me that I was the most unfortunate person they ever met, because being charged with double rape, and this biological evidence from the actual rape kits, the swabs, cuttings from the undergarment seam, all those things were intact in those 5 microscopic slides from both rape victims. So what it did, it excluded me. And the individual that you're asking about, as far as him ever paying for the crime, statute of limitations would not allow him to be prosecuted. In fact,
but it did point to him?
No, it did not, because they were never allowed to actually DNA test. They couldn't approach him because he was never incarcerated.
Do they know who it is?
They found out who he was through the 2 people that were charged with me, 2 blood brothers that were their homeboy they grew up with. So that's how they found out who he was, but he wouldn't even come forward even after knowing that he would not be charged to even testify on my behalf to try to free me prior to DNA testing.
Mr. Hunter, you talked about a fair share of resources. Is is a prosecutor's office in an area more expensive to run than defense?
Generally, yes. It really depends on the area.
I mean, they have to prepare all cases. Some cases where the person, you can do a plea deal, there's not a whole lot of defense work to be done.
Well, if you look, that's true, Mr. Chairman. If you look at the typical, what we call district court, which is our lower level court, there's usually an assistant district attorney who is in there handling cases, and there might be 100 or 150 cases that are resolved in a day with one assistant district attorney in that case. Defense lawyers, you cannot have 150 clients in one day. Even this on the 7-minute rule, you can't have 150 clients in one day. So we talk about parity in funding. They're really not mirror image functions, especially I think at the lower level where a lot of the work has been done by law enforcement and the prosecutor is just carrying that to the court. Defense has a duty to do an independent investigation, which I would say is almost never done in lower level cases, and then advise the client on how to proceed. So that's quite a different role than the prosecutor's role, which is largely consulting with the arresting law enforcement officer who's already done an investigation and a report. I know that doesn't work. You don't need to tell me, Mr. Johnson, that doesn't work perfectly every time. But the point I'm making is that the roles are really not mirror images, and I think sometimes that can make it even worse, the disparities in funding, especially at the lower level.
Let me ask Mr. Hall, on the lower levels, what is it about misdemeanor cases that makes resolving ineffective counsel issues more difficult?
Misdemeanor cases usually don't end up being even a part of the ineffective assistance claims that are brought. Those are brought by people in prison saying, I shouldn't be here at all because my lawyer was ineffective. But people are herded through the criminal justice system at the low end for misdemeanors. They're given offers they can't refuse, take probation and be done with it, and then they find out later that that probation or short term in jail ended up costing them more. For instance, the poor are especially vulnerable for those types of outcomes because they can't pay a fine, they can't pay a lawyer, so they end up going to jail in lieu of paying a fine sometimes. And then they find out there's collateral consequences. For instance, somebody pleads to an offense, and now they can't stay in public housing anymore. They're not entitled to some type of public assistance, and even get kicked out of college for misdemeanors.
Do most states have automatic rights of appeal de novo for misdemeanors?
Many states do. I don't know how many do. My state, for one, does. Most of the states around me do. But that doesn't mean that those rights will ever be exercised. The person goes off to jail, gets a 5-day sentence, for instance, and that may cost the county $500 to keep that person for that 5 days. And that's an added cost when they shouldn't have never been prosecuted in the first place, because it's an over-criminalization problem in part. It's throw everybody in jail, as Mr. Conyers said, also in part. And the focus of the system just seems to be convict them all, let God sort it out. And it should be, everybody should get a measure of justice to at least decide whether or not they're really guilty before they plead to it. Sometimes it's easier to plead than to contest. At least that's the view that they see in the lower level courts.
Well, particularly if the pleading just gets you the collateral consequences later, you don't serve any jail time now, and you walk out of court and think that's the end of it until you try to get a job.
And you don't even know about the collateral consequences sometimes for years. Sometimes you find out the next day, but sometimes you don't find out for a long time.
Professor Luna, you mentioned the moral hazards. Is one of the moral hazards that's not being paid for in this system the fact that you're not having good literacy programs in the 3rd grade, and those children get into the cradle-to-prison pipeline?
That's a problem. I don't think it quite fits the definition of moral hazard, but it certainly is a problem. This is the possibility that individuals, I mean, this is in a very real sense, and I don't disagree with anything that has been said here, that in a very real sense, the criminal justice system has become a war on the poor. And that should concern everyone. I have no doubt that is something that needs to be addressed. Again, my concern is how to address it. rather than whether it needs to be addressed.
One of the things that keeps coming up is the excessive caseloads. Why can't lawyers ethically say no to additional cases when they are obviously, 19,000 in Louisiana? Why don't they just say no and not accept the cases? Mr. Johnson?
Mr. Chairman, oftentimes the defenders have a lot of pressure put on them by the court. The court will tell them that they're going to defend this person, and it takes a lot of courage when you're supporting a family as a defender to say no and put themselves at risk, and then the head of their agency may not be as sympathetic to them saying no. It's both an individual and an agency responsibility to draw the line. And there's a lot of pressure in the system for them to just bow to the wishes of the system.
And do any lawyers put on the record the fact that at the beginning of the case that they've not had an adequate time to prepare because of their caseload, and let the appellate courts see that?
Mr. Chairman, I understand that has been done around the country, but they'll put it on the record, and it won't be of any significant consequence that they put it on the record and then go on from the, again, all the circumstances surrounding.
Because ineffective counsel is what, harmless error?
Right. If I might, Mr. Chairman, add one thing on another matter that Mr. Conyers had, Chairman Conyers had raised, and that is there are a lot of prosecutors in this country who think that incapacitation is protecting public safety, and they honestly believe that. That is, I suggest, and if I'd like to have you consider this aspect of it, we do criminal justice in the United States quite differently from the rest of the world. Every place else in the world, prosecutors are appointed. They're not elected. Every place else in the world, they're big systems where people in those systems have a time to think about criminal justice policy and what's the appropriate thing to do. I do a fair amount of work with international prosecutors and understand the way that they can think about criminal justice systems in their system. In the States, we have over 2,400 little empires like mine, where I am the absolute authority as to criminal justice. Most of the prosecutors of that over 2,400 are in very small systems. They're moving cases. They don't have time to think about criminal justice policy, what's right. The answer for them is real easy. Put them in prison. And it doesn't go any further than that. Very few big systems like Chicago or LA where they sit back and can think about and study. In other countries, you have one prosecution system in England, one in Ireland. In Canada, it's one for every province. In Australia, it's one for every state. And they sit back and really think about criminal justice and what's the right thing to do. In other countries, prosecutors don't lobby. In the States, we hire lobbyists. We're in the halls of the legislature every day. That influences criminal justice policy. And that is what drives the criminal justice policy in the States, and in my mind, the major reason that we have the type of system we have.
Justice Billings.
One obviously should never speak unless they have the facts on which to base their statement, and I just want to correct my sort of side comment about a study on disparity of sentences. What this was not disparity of privately assigned counsel versus appointed counsel. It was disparity between guilty pleas and going to trial. And this raises another issue that we really haven't talked about that is also a matter of great concern within the indigent defense system, and that is that because of the inability of counsel to investigate, because counsel aren't appointed soon enough, we have a lot of people who are sitting in jail awaiting trial. And that period of time that they're sitting in jail awaiting trial, they lose jobs, they are unable to support their families. They reach the point where they will plead guilty simply to get out of jail. And the study that I was remembering incorrectly was that following the sentences following jury trials are 44.5 months or 3 3/4 years longer than those following guilty pleas, which is a pressure on people to plead guilty, because if they exercise their right to jury trial, they will be punished for exercising that right, which is another travesty within our system.
And I would suspect that there's a difference between court-appointed and public defenders. Public defenders are criminal law specialists. Court-appointed, you don't know what you're going to get. You might have a real estate specialist taking a case that they don't know a lot about, but a public defender is a criminal law specialist, so I think you might get better representation there if there is a rational caseload. Mr. Hunter?
Well, I think you get more variety. You can get absolutely great lawyers who are court-appointed. Most real estate lawyers, frankly, unless real estate's terrible, they're not interested in accepting an appointed case. But you can also get, they're not real estate specialists, but they're lawyers that, frankly, are not making it in the private sector, and so they're appointed cases. You don't have to, your client doesn't have to agree to hire you. He's stuck with you. And that's, I think, is another problem with our indigent defense system that we haven't touched on, is the fact that clients have so little power. In private practice, and lawyers in private practice, the market operates in some way. People don't always choose wisely when they have the money to hire a lawyer, but in general, I think the market works. We don't have that in indigent defense. I mean, one of the innovations I would love to see is to have a system where people who require appointed counsel get to pick their lawyer from a list. I just think that one thing might make a big difference in both the way lawyers feel about their clients and about the way the client feels about the lawyer. One thing about a hired lawyer is you've committed to that lawyer. You went somewhere and you decided, this is the person who I want to represent me. If someone is just presented to you, of course you don't have the same feeling. You didn't make the decision, and so that's one that wouldn't cost any money. It would just be a different way of trying it, and I would like to see that. I think that might, that's an innovation I would just like to see tried somewhere and see where it goes. But I think that would be an improvement without spending any more money.
Thank you. Mr. Hall, did you have a comment?
Yes, sir. Again, I would suggest you look at the federal model. In my jurisdiction, there's probably 20 assistant U.S. attorneys and maybe 7 in the federal defender's office, but the federal defender cannot represent everybody. In a multi-defendant conspiracy case, they represent one, and then the rest go to appointed counsel under the Criminal Justice Act. And in the Eastern District of Arkansas, there are about 5,500 to 6,000 lawyers in that district, but only 39 are on the appointed list, and they have to go through screening by the district court to get on the list. They're all criminal law specialists, and I'm proud to say I'm on that list.
That's in the federal system.
That's in the federal system.
I want to thank our witnesses for being with us today. The members may have additional written questions for witnesses, which we'll forward to you and ask that you answer as promptly as you can so the answers may be part of the record. The Brennan Center for Justice has submitted written testimony, which without objection will be included in the record. And also the reports that I indicated, Justice Denied, America's Continuing Neglect of Our Constitutional Right to Counsel, by the report of the National Right to Counsel Committee, and Minor Crimes, Massive Waste, Terrible Toll of America's Broken Misdemeanor Courts by the National Association of Criminal Defense Lawyers will also be made part of the record. Without objection, the hearing will remain open for 1 week for the submission of any additional materials, and without objection, the subcommittee stands adjourned.
Hey, Erik, it's very nice to meet you.